Hi, and welcome to the fourth episode of my vlog, Personal Injury Lawyer Tips. My name is Andrew Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll discuss what the 6 elements of a cause of action for negligence is in tort. As a tort lawyer specializing in catastrophic impairment law specifically, and personal injury law generally, I spend the vast majority of my time working on negligence actions and finding creative solutions to effectively deal with the problems of negligence law. So, the legal concept of negligence in my area of work is easily the most important term to comprehend as it pertains to establishing tort liability. This, of course, begs the question, what is negligence within the broader context of tort law? The term negligence has both a narrow and a broader meaning within the context of tort law. The narrow meaning refers to the conduct or behavior of the person who committed a wrongful act against you, which falls below the requisite standard of care of a reasonable person in the particular circumstances in question. The broader meaning, however, refers to what constitutes a cause of action for negligence, which entitles you to commence a tort action to seek an award of damages. If you want to learn more about what damage awards in the form of monetary compensation you may receive following a successful tort action, if you've been injured in a motor vehicle accident in Ontario, then watch episode number 3 of my vlog called What Damage Awards Do I Get from a Successful Tort Action? Or read the blog of the same name. In regards to the broader meaning, in order to establish a cause of action for negligence, which will lead to civil legal liability and entitle you to commence a tort action in the Superior Court of Justice, you will have to satisfy the 6 elements of a cause of action. The 6 elements of a cause of action for negligence are as follows. 1. Breach of standard of care. 2. Sustained actual damage. 3. Causation. 4. Duty of care. 5. Proximate cause and remoteness. And 6. Contributory negligence. In regards to the element of a cause of action for negligence known as a breach of standard of care, the defendant's conduct or behavior must be negligent in the sense that it constituted a breach of the requisite standard of care set or established by the law. This issue, which is nominally known as the standard of care issue, easily takes up the most time and is the most contentious in negligence actions. The issue essentially asks the question of whether the conduct or behavior of the defendant departed from the standard of care, an objective standard that a reasonable person would have exercised in the same circumstances. The application of this objective standard of the reasonable person ranges from no expectation of compliance on one end of the spectrum, as it relates to very young children and certain mentally, physically disabled persons, for example, to a higher expectation on the other end of the spectrum, as it relates to professional persons acting within the course of their specialty, for example, such as, but not limited to, lawyers, doctors, engineers, etc. In regards to the element of a cause of action for negligence known as sustained actual damage, you, as the plaintiff, must have suffered some actual damage. When we're talking about damage, we mean the actual head of damage or loss, for which I'm claiming on your behalf in the form of an award of monetary compensation. Examples of a head of damage or loss are, not limited to, general non-pecuniary heads of damages or losses, such as pain and suffering, loss of enjoyment of life, loss of amenities, past loss of housekeeping and home maintenance capacity, etc., and pecuniary heads of damages or losses, such as loss of income, loss of earning capacity, medical and rehabilitation expenses, cost of care, hospital bills, future loss of housekeeping and home maintenance capacity, out-of-pocket expenses, etc. The legal term damage is different from the legal term damages, as the latter specifically refers to the amount of monetary compensation that should be paid to you by the tortfeasor, whose negligence caused you to suffer damage or loss. If I can't prove that you suffered actual damage or a loss, then the defendant is not liable for negligence, even if his or her actions were deemed to be negligent and that they fell below the requisite standard of care that a reasonable person would have exercised in the particular circumstances. In regards to the element of a cause of action for negligence known as causation, as the plaintiff, you must prove that the damage you suffered was caused by the negligence of the defendant. Therefore, I'd have to prove that there exists a causal link or nexus between the tortfeasor's or defendant's negligent conduct or behavior and the loss or damage you suffered, which is nominally known as the cause and fact issue in a negligence action. The Supreme Court of Canada established what's known as the but-for test to handle this cause and fact issue, which can be expressed as follows. But for the negligence of the defendant, you wouldn't have suffered your loss or damage. If I can't prove that the defendant's negligent conduct or behavior caused your damage or loss, then the defendant is not liable for negligence, even if his or her actions were deemed to be negligent in that they fell below the requisite standard of care that a reasonable person would have exercised in the particular circumstances. In other words, if you would have suffered your damage or loss in any event, irrespective of whether or not the defendant acted negligently, then his or her negligent conduct or behavior would be deemed not to be the cause of your damage or loss. However, even if the defendant's negligent act wasn't the only cause of your damage or loss, then he or she can still be found to be legally liable to you if the defendant's negligent conduct or behavior materially contributed to the damage or loss you suffered by at least 25%, and as such, would fall outside of what's known as the minimus range, so as to be deemed a contributing factor. In regards to the element of a cause of action for negligence, known as duty of care, there must be a duty to not act in accordance with the negligent conduct or behavior displayed by the defendant in order to avoid the kind of damage or loss you suffered, which is recognized by law in the form of a legislation and/or a regulation. For example, the duty to drive a vehicle in Ontario with due care in order to avoid a motor vehicle accident is identified in Ontario legislation and regulations, such as, but not limited to, Ontario's Highway Traffic Act. In regards to the element of a cause of action for negligence, known as proximate cause and remoteness, the negligent conduct or behavior of the defendant must be a proximate or more immediate cause of the damage or loss you suffered. In other words, the damage or loss you suffered can't be too remote a result of the defendant's negligent conduct or behavior. Lastly, in regards to the element of a cause of action for negligence known as contributory negligence, your conduct or behavior as the plaintiff, if deemed negligent in and of itself, in some circumstances, can either completely bar or limit your recovery of the loss or damage you suffered as a direct result of the negligent conduct or behavior of the defendant. These circumstances create what is normally known as a liability issue, where the degree of liability of the negligent defendant is reduced by a percentage that's reflective of the degree of your negligent contribution to your own damage or loss. Depending on your specific conduct or behavior that's deemed negligent, the defendant may employ, but not limited to, the following defenses against a tort action that I bring on your behalf. 1. Contributory negligence. 2. Voluntary assumption of risk. And 3. Illegality. An example of the defense of contributory negligence in a tort action for personal injuries suffered in a motor vehicle accident is where a defendant claims that the plaintiff was contributory negligent for failing to wear his or her seatbelt. The defense doesn't exonerate the defendant of his or her negligent conduct or behavior that caused the motor vehicle accident, but rather it will potentially reduce his or her liability. The reason is because they are arguing that but for the absence of the seatbelt, the damage or loss the plaintiff suffered wouldn't have been as severe or as catastrophic. The defendant is essentially arguing that the plaintiff contributed, ever so slightly, to his or her own damage or loss, and therefore, the degree of the fault should be reduced accordingly. I hope you found this information valuable. Rudder Law Group's website is your one-stop source for answers to all of your legal questions concerning catastrophic impairment law and personal injury law. If you want more information, then please read my blog of the same name called What is the Cause of Action for Negligence Action in Tort? In my blog, I go into more detail in all of the 6 elements of a cause of action for negligence I mentioned in this blog, as well as provide links to other blogs, such as what are the steps in a tort lawsuit for personal injuries, which provide additional information you'll find helpful. I hope you found this information valuable. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at rudderlawgroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs of valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you, and I'll see you soon in episode 5 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.